The first case to come before the court is State of Ohio versus David Frankowski. And you both will have 15 minutes to present your arguments. And obviously the appellant will have, oh, you moved around on my screen, sorry. The appellant will have up to 5 minutes for rebuttal. And we have read the briefs. We're ready to proceed. The only thing that I would caution you about, we are being live streamed. We're being recorded for YouTube. And in any arguments, but especially the ones that appear online, we want to make sure that you don't mention any names of any children or the victims. So if you have to refer to somebody, you refer to them as the victim or as initials or something. So gentlemen, if you're ready to proceed, the court is.
Your Honor, Joe Patatius on behalf of the appellant. If necessary, I'd like to reserve 3 minutes.
Okay, that sounds good.
All right, Your Honors, focusing on our briefs, and I know that everyone has read them, and I apologize for the length, but we do have 5 assignments of error here, starting with the first. And I do think the first is the most important because it involves the use of 404B evidence, which is a difficult issue. And it's a difficult issue for trial courts to determine and assess what is admissible and what is not admissible. And I think in this case, it's almost directly on point with State versus Hartman out of the Ohio Supreme Court, which came out in September of 2020. In Hartman, it was argued that the evidence being introduced was for identity, and it was for modus operandi. In other words, a behavioral fingerprint of defendant Hartman there. At the trial level in that case, I had objected to its admissibility. I said there's no identity. This is just propensity evidence, and that's kind of what happened here. The 404B evidence ranged from a car fire, infidelity that was never noticed prior to trial. The state did not comply with the rule to place the defense on notice of what the purpose for the admissibility would be. Nevertheless, they did ask questions before trial, filed a motion in limine. The court conducted a brief hearing, which I think appears in, if I'm not mistaken, about 275 to 278 of the transcript is where it starts. Initially, the court rules that this is coming in for identity, as in the identity of the defendant. The identity of the defendant is never, just like in Hartman, it was never in question. The issue here is the defendant issued a denial of the charges. And when a defendant says, I didn't commit this offense or I didn't commit this crime, that doesn't mean the state automatically gets to use identity evidence. And that's something that's laid out in the Hartman case, which of course adopts the Williams standard. And it's important to note too, that while the state cites in its brief that modus operandi doesn't necessarily have to be similar cases, that's not what the Supreme Court in Hartman ruled. In Hartman, the Supreme Court moved away from that standard, moved away from that definition, and ruled that modus operandi has to be so attached to a defendant that it has to be essentially their identity. In other words, this is how this defendant commits crimes. He robs a bank at a certain time with a certain procedure, or he does certain types of steps leading up to it. Here, there's no similarity between a purported car fire, an infidelity, and a burglary. There's no connection.
Let me just ask you
questions.
Why it's even other acts and why it's not just background information to explain what actions the police took and what actions the victim took.
Absolutely, Your Honor. And the first step there would be an analysis as to relevance. Just because somebody takes an action or takes a step doesn't necessarily transform it into admissible evidence. A car fire in another jurisdiction, which was never indicted and which was never the subject of a criminal charge, doesn't prove whether or not a defendant by stealth, force, or deception entered into a house and with the intent to commit a criminal act. There's no relevance to that. It is in fact another act. So the first step is relevance, which would be that background material that I think you're asking. But the next step is, even if it is relevant, to show why somebody acted or why somebody did something, 404B is the next step. Is it admissible? Because that's, if you go to Williams, that's essentially.
Well, I guess what I'm wondering though is, I guess what I'm asking, relevance obviously is another issue, but I'm trying to understand why some of it even comes within 404. Because every action that a defendant does in his life is not another act.
Well, it's not, but here, these are what I think if we read the full title of evidence rule 404B, it's other bad acts. And
Mhm.
certainly infidelity is a bad moral act. Arson is a bad criminal act. So not all acts are admissible just on the face of our rules. We're not allowed to, either party, but in this case, the state's not allowed to introduce other bad acts for the purpose of, and here they asked specifically to use these other bad acts in order to establish identity. We have to look at what the state asked for, and that's determinative of why they were seeking. This shows kind of the reason behind their request. And I think the court's question is good and legitimate, because certainly not every act is a bad act, but we do have that, for lack of a better term, filter, that we filter out what acts would be admissible and proper to put before a jury and what acts would not be proper. In other words, we filter out intentionally bad acts unless they fit a limited criteria. In the Hartman case, the first bad act was purportedly molesting his 16-year-old stepdaughter. And then the current act that he was being prosecuted for was the rape of a sleeping adult woman. The Supreme Court said that isn't even enough for a modus operandi or an identity. They're not closely enough or related. So here, I fail to see under the Hartman test how a arson then would be dispositive of identity in a burglary, where if we look at the burglary, there was never, and I think the state agreed with this to a degree at trial because they asked for a lesser included, there was never any evidence of criminal intent introduced. So it's not as if he committed the arson to hide and cover up a burglary, which would be arguably a common plan. There's no connection there, which does, as I'm talking and thinking as I go here, one of the comments the prosecutor had made in his closing argument was and I know I'll address this in the misconduct argument, but it's relevant here because the prosecution stated that was a crime committed in another jurisdiction. We can't even prosecute it, but that's not true. If it's a common scheme, a common plan, a common ongoing transaction, our venue rules allow any county where any one act that's connected in a common plan, scheme, or design to be prosecuted in any one of those locations. So if this truly was an arson that was truly related to the activity that happened in Medina, Ohio, Medina could have brought and could have had jurisdiction over it. But because as the state conceded below, they couldn't have brought it. They couldn't have brought it because it wasn't really connected.
Counsel, I'm going to interrupt you because I'm trying my darndest to have you take a breath, and it hasn't happened yet. So,
just interrupt me, please.
I want to go to a couple things. First thing, I want to go way back to your statement that basically identity has nothing to do with this. I'm finding that to be, inconsistent or incongruent with the fact that your client denied that it was him. And I've read Hartman, and I've read Hartman, and I've read Hartman, and I'm not sure that that's what Hartman says.
Your Honor, if I could, and I guess I have the benefit of having lived Hartman at each stage of the game, so to speak. If you were to go to paragraphs 12, I believe it's 12, 36, and 37, they address that issue squarely. In Hartman, identity was not the issue. It was the denial of the crime. And the trial court in Hartman, when I said, and I argued at the trial court level, we're not contesting identity. In other words, you can tell the jury, the person
I get that. But in this case, your client says it wasn't him, correct?
He
maintains that it was not him. Is that correct?
That's correct. Absolutely.
Then identity is the issue. How is it not the issue? I guess is what I'm trying to figure out.
Sure. And the way in which, so in Hartman, we said you can claim identity. The victim knows who Hartman is. She can identify Hartman. Here, the purported victim can identify Frankowski. So identity is not an issue. It's a denial of the charges, which is different. It's not as the purported victim in this case isn't saying, I don't know who did this, and the police use 404B evidence to then come back and connect the crime. That's the difference. That's what identity information is supposed to use.
But that's modus operandi stuff. That's the, what we used to call the, fingerprint of identity. Aren't those two different things?
I would respectfully disagree and say
they
are not, because there's a difference between the defendant saying the purported victim in this case is going to identify me, and the purported victim saying, I don't know who did it. And the police using evidence to prove that this is how this person commits these crimes. In other words, their behavioral fingerprint. So just because the defendant says, I didn't do it, doesn't automatically open the door to identity evidence. And that's what Hartman is saying. Hartman is saying just because the defendant says, that's not me, I didn't do it, doesn't mean the state now has carte blanche to use all bad acts against them to say, hey, we think he burnt my car. Not even, again, I want to emphasize in this case, they didn't actually have evidence and they didn't prove he committed that arson on that car. It was just, I suspect he did it. He was never even prosecuted for it. He's never been prosecuted for it. So we're using conduct that has never been proven to just imply that Mr. Frankowski, in this case, is a bad guy. He has the propensity to commit these bad things, these bad acts. Therefore, it must be his identity. So there's a difference, and I think it's an important difference. Just because the defendant does not come out and say, or a defendant, just because the defendant rather comes out and says, the victim can identify me, but I didn't do the crime, doesn't open the door to identity evidence. And that's where Hartman departed from the other line of cases leading up to Hartman, because leading up to Hartman, that was a very common argument, even going back to when I was a prosecutor. If the defendant said it wasn't me, well, now under 404B, the prior cases were identity is in play. After Hartman, identity is in play, but only when identity is truly an issue. Because here, Frankowski is not saying the victim cannot identify me. He's just simply saying I didn't do what she's accusing me of. And that's an important distinction, but it's a distinction of significance.
And there you're trying to get into the trespass argument, I guess.
Yes, and I don't often argue sufficiency or lesser included in these arguments. I know it's an argument I have to raise, but here I do think it is a relevant argument to raise and worthy of our time here. In this case, if you look at the evidence in the light most favorable to the state, Mr. Frankowski and the purported victim had a negative relationship, and Mr. Frankowski is purported to have, I think it was a Ring doorbell. There's some type of video issue before saying, hey, we think this is Mr. Frankowski coming on in, but he didn't steal anything, he didn't take anything. He allegedly left 4 letters. And I don't believe the contents, and I could be mistaken, so please, if I'm wrong, I'm not trying to imply. I know I have having a mental block. I don't believe the 4 letters were actually even read into evidence. So where is the criminal intent?
Counsel, you are in your 3 minutes. If you'd like to save those, or if you'd like to continue, that's up to you.
I would like to save them. Thank you, Your Honor.
Thank you. All right. So for the state, you have 15 minutes.
Thank you. Good morning, Your Honors, and may it please the court. I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the appellee of the state of Ohio. I'll start with the other X evidence as well, and I'll start with the fact that certainly identity, without a question, was an issue in this case.
Counsel, can you hold on just 1 second? I apologize. I just want to ask Mr. Is it Patucci? I don't know if I'm saying his name right.
It is, Your Honor, yes.
Okay, I didn't see you, so I wanted to make sure we hadn't lost you.
I had to blow my nose, and I didn't want to put that in.
That's fine. After we lost Judge Callahan, I wanted to make sure I didn't lose you. Okay,
No,
I
Your
apologize.
Honor. No, thank you.
All right, you can continue. Sorry about that.
Just in terms of the facts of Hartman versus the facts of this case, I could not be more starkly different. Hartman was a rape case, and among acquaintances, the question of which was whether it was consensual or not. The question was not identity in that case. The question here was, you had this victim who's at a softball game in Willoughby, and she looks down at her phone and she sees on a camera that's inside of her apartment, she sees her ex-boyfriend breaking into her apartment. And his whole defense is, that's not me on the camera. He contested his identity. I was not the person who was there. I wasn't there. Now he's attempting on appeal to go with a completely different argument. Now apparently he's wishing he had gone with the, actually I was there, but my defense counsel should have requested a trespass instruction because I was there, but actually I didn't commit any crime outside of the trespass, which is also untrue, of course. There's an eyewitness, the first witness at the trial, who saw this whole. He elaborately drills into the door and breaks the door, shatters the door frame. So he commits criminal damaging before he even gets through the threshold. So he's committed burglary already at that moment. And that's not even to say what happens next, which is he goes in there and he destroys some blinds. That could also be criminal damaging, criminal mischief, disorderly conduct, you name it. The Christmas tree is tipped over. Christmas presents are all in disarray. Again, you could have criminal mischief, disorderly conduct, you name it. All sorts of crimes are being committed in this apartment to justify, at the very least, sending a burglary charge to the jury. But I'll get back to the car being set on fire. And Judge Carr's point or question, I should say, is a good one, because I think it is largely background information in terms of a timeline of what actually happened that day. This is all part of a course of conduct. This is not some bad act that happened years before that we're dredging up. This is literally just explaining to the jury what this victim's movements were on that day and why she couldn't get back to her apartment. Her car had been torched in a parking lot in Willoughby while she was in a softball tournament. She walks outside and it's on fire. So that's why she's calling police saying, "Oh my God, and now I see my ex-boyfriend at the same time on this camera, and I can't get home. I need someone to get over there because I think he's breaking into my house." So, it's a timeline as much as anything. And I would say, there is obviously all the common scheme and plan. I mean, the whole thing. If her car is burned out and she can't get home, the car is undrivable. Well, he's got carte blanche now to go to her apartment and do whatever he wants because he knows she can't get back to the apartment. So that is part of a common scheme.
I'm sorry, let me just stop you too and ask you, did the state did the court have a hearing on this, and did the state argue that these like the car fire and I don't know, the infidelity or whatever else was involved was being presented as other acts for identity purposes?
Yes, Your Honor. The motion in limine was just with regard to the car fire, not with regard to all of the other aspects of their relationship. But certainly, and I think actually to not allow this evidence would have actually prejudiced the state of Ohio, because it was so highly relevant to what happened that day. And in terms of whether he actually did this or not, the trial court provided two separate, very lengthy limiting instructions relating to this fire. And one of them was right in the middle of the state's closing arguments. The trial court literally jumps in right then and says he's not been charged with this crime. And of course you can read it yourselves in the transcript. But then again in the jury instructions emphasized that Mr. Frankowski was never charged with this.
Counsel, let me stop you there because you're getting into one of the questions I was going to ask. The defense counsel, the prosecutor during closing argument, there were those limiting instructions from the court, but the prosecutor told the jury, well, we can't charge him because it happened in another county. Doesn't that imply that they would have charged him, but for the fact that it was in another county, and that's the only reason he hasn't been charged? So it's kind of misleading to the jury, isn't it?
Well, no, I don't think that was the statement, that's the only reason that he wasn't charged. I think the implication is that it happened in another jurisdiction, and it's still being investigated, and it was made very clear to the jury that it was never charged. So they can take that at face value. I don't think, the state of Ohio was really required to say anything else there. And I think in terms of just critical foundational background information in this case, Frankowski apparently would have liked the state to just lie to the jury and tell them that these two people were total strangers, which I guess is interesting, considering that the trial counsel, Frankowski's trial counsel, spent hours and hours cross-examining CM about all of the most intricate details of her relationship with Frankowski. And that was part of Frankowski's strategy to concoct a motive for CM to elaborately frame Frankowski for this crime. Now, the fact is that Frankowski's extreme jealousy and inability to let go of CM was critical to establishing his motive to burglarize CM's apartment in this case. Frankowski's history of terrorizing CM, whether it be by stealing things from her, hacking into her phone, her email, her social media, this was also critical evidence of Frankowski's identity. It showed, again, as was mentioned, a modus operandi, a common scheme and plan. Now, given all this, even if this court were to find that some aspect of this other act's evidence was improper, I have to submit also that this error would be harmless, given all of the other overwhelming evidence of Frankowski's guilt. And that gets, again, to the sufficiency and manifest weight, that even if you find something was improper there, even without it, you have to find that it actually prejudiced him, and it didn't, because the evidence was so overwhelming. Again, CM identified Frankowski immediately when she saw him on the phone. She actually screamed out, "Oh my God, he's in my apartment," as soon as she saw the phone. She immediately knew it was Frankowski by his physical stature and the way he was moving and the clothes he was wearing. She even recognized Frankowski's voice because the camera had audio as well. And CM could actually hear Frankowski say, "Damn, gotcha, gotcha." So again, it's interesting that the entire strategy at trial was to claim that it wasn't Frankowski on the camera breaking into CM's apartment. In his closing argument, Frankowski's counsel even suggested that CM sent a stooge over to her own apartment to frame Frankowski. And again, now with the benefit of hindsight, we have apparently a different story, which is that he was in there, but he was only there to trespass. And getting to the fifth assignment of error, that instruction was not warranted by the evidence, and the trial court did not abuse its discretion in not granting it, and there wasn't ineffective not to request it. Now, in terms of the, I'd like to touch on the prosecutorial misconduct briefly, because this comes up frequently, and Frankowski complains that the assistant prosecutor noted he didn't provide any evidence that CM staged the burglary, which his attorney promised to do in his opening statement. But the state of Ohio is absolutely allowed to comment on the fact that the defense failed to fulfill promises made in opening statement, failed to prove its theory of the case. And I would add that the assistant prosecutor's very next sentence acknowledged that the defense doesn't have to present any evidence at all. The assistant prosecutor also didn't accuse Frankowski's counsel of lying. The assistant prosecutor simply stated that in his closing argument, Frankowski's counsel presented the jury a narrative that had no evidence to support it. The state is allowed to point out to the jury that there's no evidence to support the defense theory of the case. In terms of Frankowski himself, he did not testify at trial, and no one accused him of lying about the ultimate issue in the case. The assistant prosecutor simply pointed out that certain things Frankowski told police during the investigation were demonstrated to be false. In terms of the fact that he didn't own any size 13 boots, for example. Prosecutors are entitled to significant latitude in closing arguments when they argue what the evidence showed and what inferences can be drawn. How much time do I have left, Your Honor? 3 minutes. Oh, okay. And again, the car fire, it is identity, it is common scheme and plan, but I think it is also very important background information in the case. The case just would not have made sense to the jury. The facts, the timeline would not have made sense to the jury without having heard about this car fire. It just would have been odd to not include it.
Thank you, counsel. Did you have more? I'm sorry.
Yeah, I just want to go back to, I do want to circle around to, well, I mentioned in terms of the burglary, the standard is purpose to commit any criminal offense. So that part of it certainly is a low bar. And again, several crimes were committed inside of the apartment, as I mentioned, in the nature of criminal damaging just to get in the apartment, criminal mischief, etc. A trespass instruction would have been wildly inappropriate in this case. And frankly, it also would have completely contradicted Frankowski's entire defense up to that point, which was that, as we've been saying, it wasn't him in the apartment. It simply wasn't there. So how can you request a trespass instruction? I think that would have lost all credibility with the trial court and with the jury to then at the end say, oh, now I want to request a trespass instruction after I've been saying for 3 days that it wasn't me in that apartment. And certainly I think the letters DCBO, those are critical to the CM and Frankowski's relationship, and that's explained, that he would sign in emails with that's their initials. That's all of that's the two of them and the two kids' names. He leaves.
Counsel, you're out of time, so you need to finish up.
And I would just say he basically left a calling card that it was him, a brazen calling card in the apartment that it was him. So in terms of physical evidence, very compelling. Thank you, Your Honors.
Thank you. Thank you. You have, the appellant has 3 minutes for rebuttal if you choose to use it.
Thank you, Your Honors. First, as it relates to the misconduct argument, the state of Ohio grotesquely glosses over what was said in this case. The assistant prosecutor, who has been chastised by the 9th District on multiple different occasions, quite literally accused trial counsel of creating a story out of whole cloth, saying, I've never even heard of it. I, the prosecutor, have never even heard of this. Going to the prosecutor's personal knowledge of a case, saying this attorney standing here is lying to you. That was at 10:24 in the transcript. At 10:25, the prosecutor, again, even though he's been chastised by the 9th District and called out by name, keeps going. Talking about this, he talked for 45 minutes. It was an entire story created out of whole cloth. I don't know. I've never heard of this. I don't know where any of this came from. Now we're sitting here hearing this for the first time. That's applying material that's not in the record. That goes to the prosecutor's own knowledge. And this is a prosecutor whose history here with this court, he doesn't relent, even though he's been called out before. When it goes to documents, he's directly accusing the defendant of creating fake evidence. He's commenting on judges' rulings outside the presence of the jury. He's telling the jury that, hey, the defense strategy changed after I think the phrase was, I had the jury removed from the room, we had a hearing, and you saw the defense strategy change. He's telling the jury that the trial court ruled in the state's favor on some issue, and that changed the course of how the defendant was conducting the trial. That is completely improper. That is offensive to the issue of the fair trial. This prosecutor knows better than any other prosecutor he's not supposed to say. He just doesn't stop because he's never really faced a sanction where the Ninth District says this is enough. You should know, and we reverse because of you. I don't believe that's the only reason this court should reverse. I do believe the 404B evidence was improper. And if we look respectively, I know the state says identity was not in Hartman, but if we read page 12 or paragraph 12 of Hartman, the state of Ohio in Hartman said, I want to use this information for identity purposes. It's clear as day. I know the state wants to change that now, and I know the state wants to get away from that, but that's simply what Hartman was about. Like in Hartman, though, in this case, the jury instructions, while long, were inappropriate. The jury instructions in this case, the first jury instruction deviated from the OJI and was not the standard instruction as we raised in our brief. The second instruction, just as in Hartman, was the shotgun approach. They just read the entire instruction to the jury rather than giving a narrowly tailed instruction that Hartman requires be given. And that was also the issue in Hartman. In Hartman, the trial court read to the jury every conceivable reason why the evidence may be used. It was, plan, purpose, design, lack of mistake. Every possible purpose was given to the jury, just like it was here, which the problem when the court does that is, juries trust what judges say to them. You guys are important people.
Counsel, I was waiting just like Judge Callahan for you to take over.
I don't take rest. I don't believe in breathing. Go ahead. I'm sorry.
You're out of time. You're out of time. If you want
All right, thank you. I would just finish, Your Honor, respectfully with saying that the jury instructions in this matter did not cure any harm that was caused because they were not specifically tailored as required to be done so in Hartman. Thank you.
Thank you. Thank you both for your presentations, the interesting arguments you presented today from both sides. The court will take the matter under advisement and will issue a written opinion that will be sent to the parties, as well as we will report it on the Supreme Court website. So you can look at it there if you're very anxious. Thank you again. I hope you are able to dodge the raindrops today and have a wonderful day.
Thank you, Your Honor.
Thank you, Your Honor.